Perfect. Okay, so hello everyone. My name is Justine Peeler and I am very pleased to welcome you all to this Zoom webinar hosted by the Oxford Law Faculty and the Helix Research Group. So this is in fact the inaugural seminar of our Law and Emerging Technologies Invited Speaker Series, and the first of 3 seminars this term on the theme of information governance. And we are delighted to have our 2 speakers today, Professor Jane Reichel from the University of Stockholm and Santa Slokenberga from Uppsala University, whose title is Sharing the Golden Standard, a critical view on the GDPR stand on sharing biobank data within and without the EU. So we have planned a roughly 25-minute presentation or thereabouts, followed by ample space, I hope, for general discussion. So please do make a note of any questions for our speakers or general thoughts that you have during the presentation, so you can raise them for discussion afterwards, and also feel free to raise any questions or thoughts that you have while they're speaking. So just to repeat that we are recording this seminar. Both the presentation and the discussion will be recorded, and we'll be making the recording available to stream from the Helix and faculty websites. So Jane and Santa, the floor is yours.
Well, thank you very much. And thank you very much for inviting us to the inaugural seminar. We feel very, very honored to be here. And I think I will start immediately by sharing my screen. So can you all see it now?
Yep.
Good. So yes, so what we were thinking of discussing with you today, and this worked just when I before, now it worked, is the overarching question of how should we interpret the EU golden standard, the gold standard, perhaps it's rightly called, within that is under the GDPR and the ambition of the EU to make it a gold standard. And is there a gold standard within the EU? It's the expression of gold standard is usually used for EU having a standard for the rest of the world to follow. But the question is, how does it look in return to sharing data in medical sciences within the EU? And is there an even standard there? And then the third question, can the EU gold standard conquer the biomedical world? So I'll start with the first question, sharing the gold standard. And the point of departure for this discussion and this phrase, gold standard, comes partially from this recital 4 of the GDPR, where it stated that the processing of personal data should be designed to serve mankind, not only EU, but mankind as such. And if we see different representatives of the EU, this has been discussed in the debate as being something of importance. For example, John Philip Albrecht, the member of European Parliament who was leading the negotiation from the part of the Parliament, has said that it is paramount to understand how the GDPR will change not only the European data protection laws, but nothing less than the whole world as we know it. So this seems to be quite a big thing. And also Giovanni Buttarelli, who was at this time the European Data Protection Supervisor, has stated that the General Data Protection Regulation is going to raise the bar for data protection laws around the world. So this is quite a big ambition that the EU has with the GDPR, and wanting to share this very important aspect of data protection with all. So a core part of the GDPR in this aspect is Chapter 4 on the GDPR on transfers of EU data overseas. So whenever data is leaving the EU, the requirements in this chapter has to be fulfilled. So the objective of this chapter is that EU data subjects are to be protected wherever their data is processed in the world. And this is in Article 44, the first article in this chapter. It's phrased in this manner that all provision in this chapter shall be applied in order to ensure that the level of protection of natural persons guaranteed by this regulation is not undermined. So a core question here is obviously, what is the level of protection? What is it that EU data subject is to be guaranteed? And these rules are quite complex, and this is not the time and place to go into them in depth, but we could just mention that there are different avenues that you could ensure this protection. One avenue is by adequacy decision, when the Commission takes a decision on an entire country or a region or part of that country to state that if you transfer data to these parts, they are adequate. The protection level of protection is adequate for EU data. So then you could transfer freely for this. And here we have seen the two Schrems case in relation to transferring data to the US, that these, in order to uphold this level of to achieve an adequacy decision, the level of protection should be rather high. And if there is no adequacy decision, there are other avenues to use under the heading of appropriate safeguards. And this is something that is organized for this, either for a specific transfer or under a more general decision. So there could be binding corporate rules or standard protection clauses also enacted by the Commission, or a code of conduct approved by a competent authority. And here we have, we know that the BBMRI ERIC is trying to work to develop a code of conduct. Perhaps we could come back to that. It's not entirely easy, as I understand it. Or there could be contractual clauses approved by a competent authority in a member state. So, and also if for these appropriate safeguards, the level of protection should be rather high, so to satisfy the criteria of ensuring the EU data subjects their rights. And there are also derogations for exceptional situations when none of the above are applicable that can be used, but it's not something that you would use for the basis of a research project, for example, but more in an individual cases. And we might be able to come back to that for example, for a COVID-19 situation, could that be applicable? But on the other hand, if we turn to transfer of third country data into the EU, we see that it's a bit of a different picture. There are no specific rules in the GDPR how this should be ensured. On the other hand, once the data are in the EU, processed within the EU, the GDPR is to be applied by controllers in the EU in its entirety. So the protection should be there, but however, it is a bit difficult to foresee how exactly the enforcement of these rights and the supervision of these rights will take place, and if the data subject in the other parts of the world are aware of this protection and so forth. So this question is not really, the GDPR does not pay much attention to this question. And with this, I leave the floor to Santa to discuss the gold standard from EU internally, from a view from Article 89.
Yes, thank you, Jane. We can move on to the next slide here. Yes, we don't have a unified approach within the European Union or a definition of how we see how we define a research regime under the GDPR. In the work that we did within the framework of Project Be Free Africa, where we focused on data sharing between the European Union and selected African countries, we looked at the research regime as consisting of 3 main limbs. The first one would be then a legal basis, the second one would be individual rights, and the third one would be adequate safeguards. And then today I also use these 3 as lens through which I look at what happens with the fragmentation within the research regime. We can go to the next slide. If you look at legal basis, in scientific research, we can draw a distinction between primary and secondary research. The GDPR doesn't try to make this kind of distinction. At a principal level, if you look at scientific research, it has been given some prominent role under within the concept of legal basis, though we can find that only in Article 9.2 and not 6.1. And as we know, to process genetic data for scientific research purposes, we need to meet both one provision of Article 6.1 and one provision of 9.2. Here what we see is that the GDPR has created in total 60 possibilities to 60 different combinations, if my mathematics now and combination theory is not failing me, in how these adequate legal basis requirement could be met. And if you look at scientific research specifically, we know that the provision mentioned in Article 9.2J is not meant to exclude other types of legal basis if they could be relevant. So it seems that there could be at least 3 different legal bases that are possible under Article 9, and some authors have claimed that there could be 5. One could explore up to 8, depending on the context of research and the setting research is taking place. So in total, we could talk about between 15 and 40 different combinations to process personal data, genetic data for scientific research purposes. We can go to the next slide. The next limb of scientific research regime we looked at was individual rights. They are regulated in 2 main places in the GDPR, Chapter 3 and of course Chapter 8, which focus on remedies, liability and penalties. But if you look at Chapter 3 for a moment, we see that there are several level derogations possible. To begin with, there are direct derogations under Article 89 that can be found in 3 different articles regulating individual rights. That is, right to be forgotten, right to information, and right to object could be directly derogated from. If the other derogation is avenue is under Article 89.2 that requires national implementation, and that opens up a possibility to derogate from access rights, rectification rights, jurisdiction rights, and right to object. If you look at how Article 89.2 is constructed, this list of articles is separated by a comma, and then we have a conjunction and. But it doesn't seem that it is all or nothing approach. It could be that the member states have freedom in selecting which kind of rights they would allow in the national legal order to derogate from, and which they consider as too important to enable derogations. So if we go to the next slide, then here we see that within the project Be Free Africa, one of our colleagues who's also here in this room, she surveyed different European Union member states, just specifically looking at how member states have implemented this derogation. And from Olga Zerdatu's work, we see that there are 3 different approaches. Some member states refrain from implementation in entirety. Some member states did partial implementation, that is, did the selection of those 4 possible articles, and some member states did full implementation. And the same findings are now reflected in a more recent study that was commissioned by the DJ Sante and published at the end of last week, though content slightly differs, and that could be explained with a bit of with 1 year delay in, or 1 year time difference in when and how research was carried out. If we go to the next slide. And here is the 3rd possibility to do derogations, and those could be different particular circumstances. One circumstance would be, for example, that one argues that particular research project relates to public interest, and we know that public interest is not defined in the GDPR, even though it's mentioned about 70 times, with different qualifiers in different places, and that could be subject for example, that would allow to derogate from Article 2021. But there could also be other derogations possible, for example, through Article 23, which was subject of discussion during COVID research times, as greater need for research emerged and necessity to remove any potential hurdles. So if you look at these derogations, it's not easy to quantify them mathematically with basic mathematics knowledge a lawyer could have. But if you look at the derogations possible under Article 89.2, and under the assumption that we are allowed to split them precisely as member states have done, then we arrive to about 24 or exact 24 different combinations that could be found in national legal orders. And if we go to the next slide. Thank you. These derogations are possible under the condition that there are adequate safeguards in place. And there is much research, of course, going on what these adequate safeguards are and what it means in particular context. But here the interesting thing is hidden, I think, behind the wording in accordance with this regulation. Depending on how we interpret it, it might lead to different approaches and conclusions regarding the extent to which GDPR is compatible with other research regulatory instruments that we have had in the field, in particular fields, for quite some time. One could argue that there is a way to look at this in accordance with this regulation narrowly, and that would mean that we focus on those measures enabled under the GDPR, such as the example we get in Article 89.1 itself, pseudonymization, or more generally privacy by design and default mechanisms that could be in place. And then, of course, there is a broad interpretation where the GDPR would accommodate different practices that are in the field set out in different research regulatory instruments and that have existed for a long time. But then the question is, and the inevitable situation is that they would become hurdle to the free movement of personal data, and they could risk undermining the GDPR's purpose. So depending on how we interpret, we could get either a more, or either a smaller or arguably larger amount of different safeguards and measures in place. So if we go back to the next slide. Sorry, if you go further to the next slide. Yes, so if we now look at the combinations and the meaning of the standard and that we have within the European Union, we see that if we had at least 15 different legal bases, but up to 40 arguably, we have at least 24 different combinations of individual rights, and we combine with a set up to an infinity number of adequate safeguards, we get at least 360 times n combinations of the gold standard for data protection within the European Union. And this becomes quite interesting if one looks at the statements within the recitals of the regulation itself, and also what the Court of Justice continues to reiterate, that the GDPR creates consistency. One can indeed question to what extent it is consistency, what implications it brings along within the European Union, and when we want to share data outside the European Union, and whether we should think about consistency in diversity. Jane?
So I'm back. So the last part of our talk is then, can the EU gold standard conquer the biomedical world? So we wanted to see a bit what does the EU mean by this ambition to save mankind, save the data protection for mankind, that is to serve mankind, I should say more correctly. And I included here a quote from Ben Veniste, Israeli law professor, who does not talk about data protection at all, but talks about this phenomena of legislating for humanity, when a country takes upon itself to legislate not only for its own country but for the world. And the example he has taken on this is when this has happened throughout history is a situation like banning slavery, banning trafficking, and these type of situations. And what he says in regards to this phenomena is that one should think of what happens to those others that are hit sort of by this legislation. And he says when states legislate for humanity or otherwise form policies that seek global standards, it is rather evident that they should bear in mind the impact of their policies on others, and that they should balance the others' interest against their own. So the question here is, what level of protection is the EU asking for other states, and is this a relevant way to go forward? And I've included also another quote here from another, this time an American law professor, Schwartz, who has studied the GDPR as consumer privacy law. And you should always, of course, be careful to make broad generalization on and comparing different parts of our legal system. I'm not a consumer law or a lawyer, so I'm not entirely sure what he's in detail talking about here, but he is very positive on this take from the EU, saying that in short, the world has weighed in and the EU is being rewarded for its success in the marketplace of regulatory ideas. And this is of course something that has been accepted, that the GDPR and the EU's strong stance in these issues has been a good example, a leading example that also has led other countries to raise the bar, as we saw also a quote in the beginning. So I think this is true for GDPR in many circumstances, possibly. But the GDPR again is very broad. It encompasses all types of processing of data in any type of legal context. And it might be that consumer privacy law and biomedical privacy and biomedical law are different, perhaps especially when it comes to issues of level of protection. What is important in one country compared to another country? I'm not sure that the details are as similar as they might be in consumer law, without again being an expert in that. So if we look at the possibilities of GDPR, of having GDPR as a biomedical legal act, to start with the traditional safeguards that are usually used in transferring, and perhaps I'm also including here now samples and health data. Traditionally, this has been done via informed consent and ethical approval, sort of the two pillars of the biomedical ethics and law. And these two functions, informed consent and ethical approval, they are the acceptance of these two as being prominent functions and tools is based on a common understanding that is manifested in both binding conventions, but perhaps even more in soft law, Helsinki Declaration, and so forth, in many different aspects. And when implementing in the individual case, these are often realized and have traditionally been realized via MTAs and DTAs. And this, as we saw previously under Chapter 5, Article 46, with appropriate safeguards, that contractual tools can be used. So it's not impossible that the MTAs and DTAs could include GDPR. But what we wanted to discuss a bit and go a bit further with, how should we interpret the requirement for transfer in Article 44, and which is also then set out in more detail in Article 45 and 46, the requirement for transfer. How is it possible to ensure the GDPR level of protection when upholding appropriate safeguards according to Article 89? Now we're trying to put these two parts together, that transferring health data genetic data or similar outside the GDPR, we should fulfill the requirements in Chapter 4. And if the GDPR level, the relevant level of protection are those that could be found in Article 89, stating what appropriate safeguards should be used when limiting the individual's rights in research. I hope you are following our reasoning here, and please come back to us if it becomes too complex. The GDPR is not always a simple tool, a legal tool to interpret. So our conclusion here is that it is difficult to define a gold standard in biomedical law, even within the EU, as Santa just explained. So what is the level of protection that should be upheld according to Chapter 5 and transferring outside the EU? Is it impossible to define this at the global level from one country to from one EU country to the other? That outside the EU, that perhaps would work, but if it's a multiple research cooperation, things might get too complicated. And another aspect that we would like to pinpoint here is this the standard a golden for EU data subject only? As mentioned previously, the focus in GDPR is merely, I would say, on export of data from the EU to third countries. The discussion on the import is, as I said before, almost, there is no such discussion. And so usually it is fine to import data into the EU because then the EU can, at least on paper, ensure that the data subjects will have the EU level of protection. But exporting can become more difficult. And this is, Santa mentioned previously, our previous research project that we were involved with, B3 Africa. We saw that it could be difficult for African countries to receive EU health data, but exporting to EU wouldn't be problematic. So what happens here is with the fairness for researchers in third countries, are they not able to collaborate on equal terms? And what, in the end, what does that mean for public health justice? Is this actually legislating for humanities, or is it rather legislating for the EU? And yes, that was our last slide. So thank you very much for that. And I will stop sharing here. So now we're back.
Thank you very much, Jane and Santa. Fascinating presentation.